Afternoon from Singapore. My name is Kevin Nash. I'm the Deputy Registrar and Center Director of the Singapore International Arbitration Center. On behalf of everyone at SIAC, we are delighted that you can all join us for the latest installment in a series of webinars that we are bringing to the arbitration community during the course of COVID-19. This seminar will be a practical behind-the-scenes look with the SIAC Secretariat, and it's styled as a case management conference with the SIAC Secretariat during COVID-19. How can SIAC help? Let's start with some housekeeping and good order points. If you're applying for CPD points, there will be one CPD point. You do need to stay for the full 60 minutes. We would also ask that you fill out our feedback form at the conclusion of the proceedings. Like all in this series of webinars, it is designed to be interactive, and it is quite a rare opportunity to have the frontline legal counsel available for your questions. We would ask that you keep your questions on SIAC's general processes and procedures and not to be asking questions on any live matters. We would also note that this is part of the series of webinars that SIAC is offering in the coming months, so please do check the SIAC website and our mailers for the next installments. On my part, I'm very happy today to have an all-star lineup of speakers from the SIAC Secretariat. We have 4 of the legal counsel. The SIAC Secretariat is a 13-lawyer team with lawyers qualified in jurisdictions all around the world. I'll start by introducing the speakers. First, we have Angela Yap, a Malaysian qualified lawyer who's been with the SIAC Secretariat for nearly 3 years. Prior to joining SIAC, Angela practiced commercial litigation and arbitration at a leading firm in Malaysia. As part of her portfolio of cases at SIAC, Angela has particular experience in complex consolidation matters, joinder matters, and some high-value construction and project disputes. Next is Lim Shi Jean. She's a Singapore qualified lawyer who practiced shipping and commercial litigation in Singapore prior to joining SIAC. Jean has administered a wide variety of disputes at SIAC, and particularly some very tricky multi-contract disputes and cases where SIAC is administering under the Interim rules. Next is Dexter Cheng, a Singapore qualified lawyer who previously worked at a boutique law firm in corporate and commercial law in Singapore. Like many members of the SIAC Secretariat, Dexter speaks multiple languages. He's fluent in English and Chinese. In addition to his casework alongside Angela, Dexter also runs the day-to-day of the SIAC internship program. So if you have any questions on the internship program, please do reach out to Dexter and Angela. Dexter, you're welcome for having even more emails today after this seminar. Next is Thea Vega, a lawyer qualified in the Philippines. Prior to joining SIAC, Thea worked at the Office of the Solicitor General in the Philippines, where she handled criminal, civil, international, commercial, and investor state arbitration cases. She was part of the Philippines delegation for UNCITRAL Working Group 3 on investor state dispute settlement reform. Let me give you a bit of an idea of the structure. We're going to start with general practices and procedures of SIAC viewed through the lens of COVID-19. We're then going to look at the commencement of arbitration and pre-constitution applications. We'll look at post-constitution, progress of the case, and other mechanisms outside administration of arbitration at SIAC. And then we will have a period for your questions. So you can submit your questions as you go, and then we will have a reserve period at the end. So Thea, let me start with you. This is not a question that I normally ask you when we are in the office, but what I think would be interesting and helpful for many of the attendees is to give me an idea of what is life like for an SIAC counsel, both when we're in the office and now that we're working remotely. So let's say that your morning starts off and you're passed a new notice of arbitration and you're meant to commence an arbitration. What do you do during the day?
So usually I've been SIAC counsel for around 9 months now, and our work generally starts with the commencement of an arbitration. We receive a notice of arbitration, but now with our physical office closed, we usually just receive all the notices via email. Then now we also still, as counsel, we still do the pre-constitution procedures, for example, expedited procedure. Then we also have emergency arbitrations, then consolidation applications. Then I've been also still continuing with my usual work for appointments of arbitrators, even while working from home. So we were able to manage a system remotely to be able to send out appointments with parties from different jurisdictions. And to think about it, it's actually very interesting that we can do this at this time of COVID-19. Then now, we also I'm actually in the process of scrutinizing some awards. Then before logging in Zoom now, I actually just received an award from an arbitrator. So our emails are more jam-packed than ever. So yes,
I noticed yesterday that you also volunteered for an extra scrutiny as well. So, what do you say when you're looking at the general activity? So obviously SIAC is fully operational. How do you see the progress of your cases? So we have around 900 active cases at SIAC. Have you noticed your cases progressing during the COVID-19 situation?
Like what you said, when we had a case management meeting yesterday, everyone's been swimming in email. So since we don't really get phone call, we get phone calls at the same time. We also get a lot of emails. So for my cases, they're ongoing from commencement letters. I think we released around 2 or 3. I mean, me personally released around 2 or 3 yesterday. Then I have some pending awards. So it's still the same. Then I have, we're going to release some appointments also soon. So I think it's very much the same, but I don't really see my colleagues physically. That's the only difference. But at least we have the weekly case management meetings that keep us sane and happy to see each other. Yeah.
If I could just press you a little bit on that, of course, for our own purposes, would you say that the user experience is functionally the same now than it might have been a couple months ago? And just to give you some further background, it looks like the month of March and the month of April are going to be amongst our busiest of those months that we've had in the history of SIAC. So from a user experience standpoint, does it still function pretty much the same? And is your functioning as counsel very similar?
I think it's the same because I've been talking to my colleagues and all of us have been answering and giving phone calls to all the counsel, to the firms who have been asking questions. And I think we've been really responsive, even if we're working remotely. So it's very interesting that we can still manage the cases during this time. And our cases are from different jurisdictions and it's still able to progress as per usual.
You have, like all counsel at SIAC, you really have a wide portfolio of cases, so different governing laws, different seats, sole arbitrator tribunal, 3-member tribunal, different nationalities of the parties. Most of SIAC's cases are international, usually well north of 80%. But as you would be aware, Singapore released the COVID-19 Temporary Measures Act on the 7th of April, 2020, and it commenced on the same day. Can you give us a sense of the potential impact on certain contracts and commercial disputes in the next 6 to 12 months?
So I think as an institution, we would like to inform the users to check this app and check whether their industries will be affected. Because for example, if you read the act, it mentions local arbitration, so domestic arbitration in Singapore under Cap 10, but it doesn't mention Cap 143A or the International Arbitration Act. So we would want the counsels or the firms to check these factors first before commencing an arbitration. Then they should also check if there's a service of notice of relief in these cases under the Temporary Measures Act. But for my cases now, I still have ongoing and I have commenced cases under the Domestic Arbitration Act. But it's not related to the cause of action is not related to COVID-19, but these are ongoing and it's probably from a prior cause of action. So even if it's under the Domestic Arbitration Act, we're still progressing with the cases. So it depends on the nature of the case generally.
And I suppose that's part of your process when you receive a notice of arbitration. You're going to ensure that there's compliance with Rule 3 of the SIAC rules, but then you're also going to have to do an extra look to see if is this governed under Arbitration Act Chapter 10? Is it International Arbitration Act 143A? Is there going to be a prima facie jurisdictional objection? This is, I guess, now part of your process when you're commencing an arbitration?
Yes, we have to double check them. we have to double check more the date of the contract involved, and then we check, as per usual, all the notices of arbitration before we commence it.
Moving away from case management, Thea, I just wanted to ask or really get your reflections on SIAC statistics for 2019. So our top foreign user was Indian parties, but our second top foreign user was parties from the Philippines. Now, of course, you've had quite a bit to do with that. We've had some excellent counsel from the Philippines in the past. Why do you think that parties from the Philippines are choosing SIAC arbitration? And what do you see as the future for dispute resolution of parties from the Philippines at SIAC?
So I think we had 122 parties from the Philippines last year, Kevin, in 2019. So it's very interesting, and it's a collaborative work from all the previous counsel, from SIAC, also from the Philippines. So SIAC is able to progress these arbitrations in an expedient manner. So we also had very successful events in the Philippines last November with the YSIAC Academy and the conference. So it's good to have these alternative dispute resolution mechanisms for cross-border transactions. And I think I worked a lot in different courts back in the Philippines, but for arbitration, it's easier now. You have like virtual hearings. You can commence arbitrations via email. So there's really some innovation in there should be some innovation in the alternative dispute sector.
We have a question that just came in from one of those excellent counsel from the Philippines that worked at SIAC before, and I think this is a practical question. Could you just really distill this down? If parties need to contact you as case counsel, what's the best way to get a hold of you? Is it email, telephone? How do they get a hold of you for an urgent query?
So you can initially you can check the SIAC website for general queries, but if it's already an existing case, you can always email the case counsel involved, and we will try to get back to you as soon as possible. But everything is hopefully via email, so we can see it as fast, and try not to send physical documents to the office or fax. It's really, we hope that you send it via email.
Now I use the term urgent query. Have you found during your time at SIAC that every case is urgent and every query is urgent? Would that be fair to say?
I think so, yes. But there's a really urgent one when we have emergency arbitration proceedings. Then I think my other colleagues would gladly talk about that later, since I think we're in the middle of a lot of emergency arbitration proceedings now, even working remotely.
And I mean, really, that is really part of what we've tried to do at SIAC, is that we want to give gold standard case management. Every case is the most important case on our docket. It doesn't matter the quantum, because we know that it's most important for the parties, which is why you guys never have a free weekend or a free evening. And I see emails coming in at 3 or 4 in the morning last night. Thea, I cannot promise you that I don't have more questions for you, so I may return to you with some more questions, but thank you for giving us the general background on how SIAC is operating right now. I'm going to turn to Jean, and let's look at some sort of commencement and pre-constitution issues. Jean, from a practical standpoint, how does a party go about commencing an arbitration at SIAC during COVID-19? How is it different than, say, 3 months ago, 6 months ago?
Okay, so if the claimant actually wishes to commence a case with SIAC, we will actually request that the notice of arbitration be filed via email. So in contrast to a situation where 3 months ago we would actually accept notices of arbitration by way of hand, now we will actually request parties to actually file any the notice as well as any accompanying annexures by way of email to us. In this regard, we also will request that all payments to SIAC are to be made via electronic bank transfer only, with proof of remittance. We do not accept checks. For new cases, please contact us actually at casemanagement@siac.org.sg for our bank details, and we will then provide the claimant with a general reference number to facilitate future communications with SIAC. And for existing cases with SIAC, the counsel can then contact the relevant SIAC case counsel or the case management officer, who will be in touch with regards to payment details for deposits.
How would you react to a situation where a claimant, the moving party, insists on filing the notice by hard copy and physical check? How would you deal with that situation?
Wow.
Or I suppose you would refer them to our guidance. But I think that, I mean, we've certainly strongly requested that parties take advantage of electronic means. We're still able to receive physical documents, but I guess the expeditious processing, it's much better to have it electronically. Would you agree?
I would agree. As you said, that it is possible for us to actually go down to our office to obtain a hard copy of the documents, but that will actually require us to apply for a permit, especially just to go down to our office. This is really quite inconvenient for us. So we really actually appreciate it if you guys could actually just file it by way electronically. That would help us a lot.
Yeah, and I guess the takeaway here is that it's actually going to be much quicker if you do file this electronically. So electronic copy of the notice, as you said, you still have to make sure those service requirements are taken care of, and then payment by bank transfer. Great. So I think one question that I'm sure that we'll see and is quite relevant, obviously there's been quite a few disruptions with COVID-19. Let's take my own decision-making power and we'll leave that to one side for a second. What about extension? So if you're a party and for whatever reason you have a legitimate case that, you know, I'm not able to make payment of deposits, what do you see the decision-making process for extension of times on payment of deposits and general extensions under the SIAC rules?
So time limits and the amount of deposits payable towards the cost of arbitration are fixed by the registrar under Rule 34 of our rules. So if COVID has resulted in circumstances that will delay any party's payment of the deposits, we'll request the party to actually make a formal request to the SIAC for an extension of time for making payment, meanwhile copying the other party and the tribunal if necessary.
Can you tell me a bit about the deposit process generally? I think the one thing that we've tried to do at SIAC is be very commercial. So the costs of arbitration are calculated in accordance with the SIAC schedule of fees. The complement to that is that we call for deposits based on the estimated cost of arbitration. Can you give us some background on how deposits are calculated under the SIAC rules and what kind of discretion exists there on the calculation?
So that would depend on whether your arbitration agreement provides for a one-member tribunal or a three-member tribunal. For a quick estimate as to, even before you file a notice of arbitration, maybe say you need to inform your client of like what are the upcoming payments for the cost of arbitration in a matter. You can actually go online to our SIAC estimate your fee calculator, where if you actually type in the number of arbitrators as well as the total sum of this total estimated sum in dispute, you can actually generate a figure which you can take back to your client to explain that this is the amount of cost of arbitration that you might potentially incur in the cost of commencing an arbitration with SIAC. So in situations where there's a non-responding respondent, I think it would be good for the claimant to actually note that SIAC also will request the claimant to eventually make payment, as parties are jointly and severally liable for any deposits that are to be made to the institution.
That makes sense. Let's look at some of these pre-constitution applications and the functioning of the Court of Arbitration. Of course, the Court of Arbitration decides many of the most important questions under the SIAC rules: jurisdictional objections, consolidation, joinder, challenges to arbitrators. We can consult with the court on the scrutiny of awards. Of course, we are very lucky to have Gary Bourne as president of the SIAC Court, and then Lucy Reed and Kavinder Bull as the vice presidents. How is the court functioning? So if you need to determine, say, an application for consolidation, you have a notice that is filed out of a string of, say, 5 contracts. The party takes advantage of Rule 6.1b, chooses to file a single notice of arbitration, and then you need to brief the court. How's the court functioning, and how is that working, say, in a situation of an application for consolidation?
So the SIAC court is fully functional. So any applications to the court will still be considered in the usual course of business. As for consolidation applications, typically it will depend on whether the respondent actually consents to the consolidation application, where both parties actually agree to the consolidation application. That would make the process much significantly faster for the parties, because it will then proceed on a slightly more expedited timeline, in which we will then determine that consolidation application. Is only in event that where the respondent actually objects to the consolidation application that it might take a slightly longer time.
Moving on to a very useful procedural tool, perhaps particularly in these situations, expedited procedure. Can a party still apply for a matter to be conducted under the expedited procedure? And I will warn you, I have a very difficult follow-up question that has been submitted by a former SIAC counsel. So can a party still apply for expedited procedure?
Yes, a party can still apply for the matter to be conducted under the EP procedure. However, such applicants should consider whether, in light of the potential disruptions caused by COVID, if it will still be able to effectively prepare and present its case under expedited timelines. However, if the President determines that the arbitration shall proceed under the EP procedure, the case will be referred to a sole arbitrator. So this can actually result in significant cost and time savings, which would be important in COVID times. As for existing cases under the expedited procedure, if circumstances change such that it's no longer possible or practical to actually proceed under the expedited procedure, a party can then consider making its application to the tribunal for the case to be taken off the EP proceedings. However, before it does that, the parties or tribunal may wish to consider Rule 5.2c, where the tribunal may, in consultation with parties, decide if the dispute is to be decided on the basis of documentary evidence only. And also Rule 5.2d provides that in exceptional circumstances, the registrar can also extend the time for the tribunal to make the final award. So we actually do have a COVID-related case where the claimant filed an application pursuant to Rule 5.1a and 5.1c of the SIAC rules on the grounds that the total amount in dispute was below the threshold level of 6 million Singapore dollars and the respondent's financial status was in peril. So the argument was made that if the matter was actually not heard on an expedited basis, there would be a real risk that the respondent would go into liquidation and that the claimant would not be able to enforce the award. So the respondent then argued that the expedited procedure would result in practical difficulties in light of COVID. There would be disruption to proceedings. The tribunal's ability to convene the evidential hearing would be impacted in the next 4 to 6 months, and that based on existing travel restrictions in Singapore, the respondent would have difficulties meeting its lawyers. Further, it was the claimant's fault because it actually delayed in bringing about the application. Nevertheless, the EP application was actually accepted on the basis of 5.1a, not 5.1c, on the grounds that a robust and experienced tribunal would be able to manage the issues in the matter within 6 months. And in any event, it was also noted that the registrar is also able to extend the time for the tribunal to make the final award.
Yeah, the question that was submitted sort of follows from that. If you're looking at the requirements under the SIAC rules for making an application for expedited procedure, so the amount in dispute is less than 6 million, party agreement, or cases of exceptional urgency. A lot of the scholarship and discussion on expedited procedure, and SIAC has really done more expedited procedure than almost any other institution in the world, is what is this exceptional urgency category? At the risk of you speaking for the president's discretion, because of course this is decided by the president, the question that has been submitted, do you see the SIAC loosening this generally very strict requirement and strict interpretation of exceptional urgency?
Well, I would not factor the presidential discretion, but I would say that perhaps it would work. The ground of exceptional urgency would work for certain contracts, which perhaps say involves perishable goods, or where, like, say, a petition for winding up has been filed against a respondent and the claimant want to get the award as soon as possible to file a proof of debt.
That makes sense. Let's move on to urgent interim relief. And as a bit of an advertisement, this upcoming Tuesday we'll be getting very much into the details on applications for urgent interim relief. But Jean, right now, COVID-19, a party needs urgent interim relief prior to the constitution of the tribunal. What should that party do?
This question actually comes at an interesting time, considering that we have just been put on notice as to 2 further incoming EA applications. So an applicant can actually file its application for emergency interim relief via email at case-management@siac.org.sg. Please try as much as possible to notify us in advance of any intended application so that we may then make the necessary arrangements to ensure that the application is processed as promptly as possible.
Yes. Okay. Thank you, Jean. As I said to Thea, we will have more questions for you But as promised to Thea, I am going to go back to Thea with a question from one of the attendees that relates a bit to general commencement. The question is, in the event that the respondent is unwilling to pay the requested deposit and the claimant does not pay for the respondent's share, will SIAC allow the proceedings to continue? Thea, this is a very common question. I'm wondering if you could elucidate on how this exactly operates in practice.
So, well, for cases, it's in the discretion of the registrar regarding the deposit. So usually it depends if there's a tribunal that's already been constituted. So if not, under the SIAC rules, you would then, under 34.6, stop the proceedings if ever there are no deposits involved. But it would always depend on the stage of the proceedings. Yes.
You know, one thing which I should point out to the audience is how all of our SIAC counsel know every one of the SIAC rules off by heart with the ease in which rule references are given. But I just want to confirm, so the respondent doesn't pay, so the claimant can pay its share, then it will have the option to pay on behalf. But the arbitration doesn't stop because, say, a respondent is not paying its share of the deposit. Is that right?
Yes, the claimant is able to pay on behalf of the respondent, and there's also the tribunal is also able to provide an award to pay the unpaid, to make the respondent pay for the unpaid deposits. Yeah. So that's also under Rule 27 of our SIAC rules for the other.
That's actually, let's just stay with that for a second, because that's actually an important provision under the SIAC rules. So you say have the claimant party pays its share of the deposits and the respondent's share, but it doesn't want deposits to be locked up for the lifespan of the arbitration. Because even as fast as SIAC is, our median case is less than 12 months, but that's still 12 months when you're without deposits. So under Rule 27G, because I can do it too, you can apply for an award on unpaid deposits. Let me give you a hypothetical. If the claimant had paid one tranche of the respondent's deposits and then had paid its own second tranche, could a claimant apply for an award on unpaid deposits when it has not yet paid on behalf for that second tranche? Because we've seen that situation a few times.
Personally, in my cases, I haven't seen that, but I think my colleagues were able to see that in one of the ED cases when they asked the tribunal to pay the deposit, to give an award for the unpaid deposits. Yep. Then the respondent filed an ED, an early dismissal case, and they were saying that they don't have the money, right? But the tribunal granted that it's not a valid cause of action, so they were able to get that award.
Yeah.
So,
one of the well, that's a very good point. One of the interesting things that we've seen with our early dismissal procedure, because exactly as you said, we've seen that used effectively for an administrative matter like the non-payment of deposits, and that's an exciting part of the provision because effectively we've imported this from 41.5 of ICSID, and now we have it in the commercial space. I think parties are getting more and more comfortable with the provision and seeing the different ways that they can deploy it. Thanks, Thea. I will move now to Dexter, and we'll look at the constitution of the tribunal onwards. Let's talk about, Dexter, let's talk about the appointment of arbitrators generally. Do you think that COVID-19 has any impact on our appointment of arbitrators and the constitution of the tribunals? We'd be grateful if you could give us your observations on what the tenor of the appointments are looking like at SIAC right now.
Thanks, Kevin. I think that there hasn't been much of an impact, or rather a negative impact on the appointment process. From my own experience, at the same time, I haven't seen a noticeable change in the level of responsiveness from the arbitrators. They have been responding day and night on there's several matters with lightning speed. So I don't think that there really is an issue with the appointment of arbitrators. Perhaps one might wonder if COVID might factor into the decision on who to appoint. But I think as with pre-COVID situations, these are just considerations that one has to take into account, and COVID is just one of them. So I don't think that there would be any real difference here.
Let's talk about the process for the appointment of arbitrators under the SIAC rules. So The default is that a sole arbitrator is appointed, but of course parties can agree on a 3-member tribunal, and they often do. If the arbitration clause is silent, a party can apply to the registrar and make the submission that the circumstances warrant the appointment of a 3-member tribunal. One thing, so if I pretend to be moderator outsider here, one thing that I think is very good about the SIAC appointment process is that it's very clear. The president, vice president make the appointment. So it's a very clear process. So you as SIAC counsel, when you're making recommendations and you're moving those up the chain, what kind of considerations do you look at in the appointment of arbitrators? Is it governing law of the contract? Is it law of the seat? What are you looking at when you're making recommendations?
Well, I think for one, I would definitely look at the nationality of the parties. If, for example, the parties are both situated in Singapore, then it would make sense to also appoint a Singaporean arbitrator who is familiar with Singapore law. But that does not preclude arbitrators from other jurisdictions such as the UK or Hong Kong. If the parties are situated in different countries, for example, one from civil law jurisdiction, one from common law jurisdiction, and it's a 3-member tribunal situation, then perhaps it would make sense to make sure that the tribunal is balanced in its experience with these different legal systems. So aside from the nationality of the parties, we would definitely also look at the complexity of the case, the sum in dispute especially. If it's a very large sum in dispute, then definitely you would want arbitrators with sufficient experience and stature to be presiding over your case. And if it's, for example, a very simple, low value employment dispute, then you wouldn't necessarily go to the top-end arbitrators who have other more complicated cases to deal with already. So I think these are just some of the considerations.
If I could just jump in, I mean, one interesting point about SIAC, because we're one of the few institutions that has the scrutiny of the award, and of course this goes from counsel to registrar, deputy registrar. So you're really able to look at how a tribunal has run the case. One thing that I think is great about what you guys do is you guys are looking at the pleadings. You're not commenting just from a superficial glance. You're really getting into the pleadings. Not only that, you're also making the recommendation on the determination of costs. So you're doing the forensics on what has actually happened in the case, how has this arbitrator performed, and then relevantly, how has the institution performed? Could have we done a little bit better? Were we really fast? Were we perfect? Or do we need to tax our own fees a little bit? So sort of taking that all together, how much does track record at the institution matter when you're making recommendations?
Well, how much does track record matter in terms of appointment, right?
Yeah. So the experience at the institution.
Well, I think I'm not gonna lie. I think realistically, we have an open office concept, so things move around very quickly. So definitely, if there are awards that really stand out, that is something that people would actually praise and share. And there's a lot to learn from that. And also, the converse is true. If an award is lacking in certain respects, then on our end, when we're doing the scrutiny process, we also hope that when we're making all these recommendations, that the tribunal would take it in and would also improve the award. And I don't think just because perhaps the first award that is submitted to us is lacking in some areas would mean that the arbitrator wouldn't be appointed subsequently for a different matter. I think we would definitely look at whether there has been any improvement and whether the suggestions have been taken on board. And that would probably factor into the subsequent appointments.
I mean, I think one thing that's fun from my standpoint, and I learned long ago to not admit how long I've been at SIAC, but it's been quite a while. And you can see the development of arbitrators, say, over the course of coming on a decade. And so you can see that arbitrators that have started with very small value cases work closely together with SIAC counsel, go through that scrutiny process. Arbitrator does very well. Next case, a bit higher value, a bit more complex. Maybe it's a different seat of arbitration. The arbitrator starts getting steeped in more governing law. Of course, I think it's well known the kind of diverse appointments that SIAC is making. So I think because ultimately all of us are arbitration fans, we really like to see the way that arbitrators are developing, and you as SIAC counsel, because you work so closely on the scrutiny, are really able to help that along. I'm gonna sort of circle back a little bit, or maybe make this more general, just from the observations that you may have in your cases. So things like expedited procedure, early dismissal, emergency arbitration, consolidation, and joinder. How are these relevant during COVID-19? What are you seeing in your cases? Less, more, about the same?
I would say that it's been quite the same to me. Whether you're thinking about applying these procedures or whether these procedures have already been applied since the circuit breaker started. I think that the purpose of these provisions is really to save time and cost. And just because that there is COVID, it doesn't mean that parties don't care about saving time and cost. So for example, the expedited procedure, if you have a case that is quite straightforward, where the facts are quite undisputed, and parties even have an option of consulting the tribunal on a documents-only arbitration, then whether there is a COVID situation or not, I don't see why parties wouldn't rely on our expedited procedure. And early dismissal of claims and defenses are relevant regardless. So the same also applies for emergency arbitration. So I wouldn't say that they have, whether the relevance has actually changed during this period.
I think Dexter, as is often the case, I'm in complete agreement. Expedited procedure to me makes a lot of sense. I think that some corporates may not have the same liquidity. I mean, obviously parties choose SIAC because we're fast, cost effective, but if you're able to get that award in 6 months, that has a way of controlling costs. Early dismissal, I think this is something that's going to start happening a lot because you're going to have somewhere along the supply chain, someone didn't perform, and there's not even a dispute as to whether they performed. They just said, well, we couldn't because there was a lockdown, we weren't able to. And so now this becomes a very interesting early dismissal question where you may be looking at the boundaries, say, of the force majeure clause. So I think that is going to be an interesting development. Let's move it a little bit along in the chronology. So in most places, or virtually every place, physical hearings no longer feasible. What are some of the alternative arrangements that parties have made in your cases, and what do you see going forward?
All right, so I have seen parties turning to video and telephone conferencing. For some of the simpler cases, like I mentioned earlier, they are even considering documents-only arbitration. And I think if one chooses to go down that road, they can actually help themselves avoid some of these logistical hurdles. But they would have to balance this against possible setting aside applications somewhere towards the end when they're trying to enforce the award, if, for example, the issues are not dealt with completely. So I was actually having a chat with my friend Elyssa from Denton's. He was telling me about his experience with the Maxwell Chambers virtual hearing facilities. So it turned out that their team had a very positive experience with the service. Maxwell Chambers provided a moderator to control feedback and ambient noise. They also had a dry run the day before. And so things proceeded very smoothly for them. I think that video conferencing, even if you're not going with Maxwell Chambers, you just need, like what we're doing now, we're doing a Zoom video conference. It can also be used for procedural conferences or for the tribunal to hear the parties on certain applications during the other stages of the arbitration. So some of our listeners would have listened to our past webinars where the panelists discussed about the pros and cons about video conferencing. I would say please go and watch those webinars because I think the views expressed there are definitely, they carry way more weight than what whatever I would say here. But my own key takeaway is that arbitration, being known for all its flexibility and innovation, really should be leading the way in this time of the COVID crisis. So just to clear the air here, SIAC doesn't actually provide the virtual hearing service, we would actually direct these inquiries to Maxwell Chambers.
Yeah, but I think there's, so I will liken it to us hosting this webinar right now. If we didn't have our very skilled business development team online, I would be very nervous. And so that's probably the advantage of having Maxwell Chambers. And then I think what you guys are doing as SIAC Counsel is that we're often getting SIAC Counsel that is joining the webinars. So I think that is helping to ensure that everything runs more smoothly. I think your sort of point about effectively saying institutions leading the way. I mean, institutions are the thought leaders in arbitration. One of the really exciting things I think that out of a very difficult situation is what tools can we develop, refine, and then take once everything goes back to normal, and we can find even more efficiencies. So I think that's a really exciting thing for an institution to be a part of. Thank you, Dexter. And Angela, I will move over to you, and I will start you with a question that has just come in. This is a general question, but let me put it to you anyways, because I think it's important for the parties to understand the SIAC fee structure. The question is, are there different fees and charges for large corporates as compared to medium and small business enterprises? Could you give us an idea of, again, of how the fee structure works at SIAC?
Sure, thanks, Kevin. The answer is very straightforward. There are no differences. We have a set schedule fee that's ad valorem, and they're all very visible on our website. So if you just go to our website and click under fees, you will be able to see the fee schedules. And another handy tool is our fee calculator. So it doesn't matter whether you're a big corporation or you're a small or medium enterprise, the fee is the same. It depends very much on your total sum in dispute. So use the calculator, and that will give you a quick idea of how much it's going to cost for the entire arbitration.
And effectively what you're doing there is you're getting your maximum exposure. So this is the maximum cost of arbitration, but then SIAC is going to determine exactly what's happened in the arbitration. And that's really kind of the advantage of the ad valorem system. But of course, parties can also choose prior to constitution, they can choose to a different form of remuneration from the tribunal. I know that you've had some of those high value cases where the tribunal is on an hourly rate. I guess you see a mix of both, but much more schedule of fees, would you say?
Yes, yes, thanks for the reminder. I actually have seen both options being used, whether it's pursuant to a schedule fee or by way of hourly rate for the tribunal's fees. Frankly speaking, from what I observe, it is largely cheaper if you go with the SIAC schedule fee, only because it is capped, like Kevin said, at a maximum. So it's easier for users, corporations to gauge how much they need to set aside in order to bring the entire arbitration to an end. So it is less predictable when it is charged by way of hourly rate for the tribunals, because if more complex issues tend to come up in the middle of the arbitration, the hours would break up. So it becomes a bit harder for businesses to plan their finances. So these are considerations that parties might want to think about. Sometimes it may be cheaper to go by hourly rate for the tribunals. Really depends on how complex the cases are. But generally, predictability, I think, is what is the attractiveness of our schedule.
Okay, we're obviously me and you, we're going to be discussing about the transmission of awards and enforcement, but we are getting a lot of questions on costs and deposits. So let's just stay with that for a moment. A question has come in with liquidity issues affecting the global economy. Can parties expect any flexibility in the manner in which SIAC collects deposits? So let's assume the much more common approach of ad valorem. What's the flexibility there? How many tranches? What's the timing? This deposit thing sometimes is a difficult message to communicate. How does it work, and what is the discretion inherent in the deposit collection procedure?
Is it for me? I'm sorry.
Yes, exactly. Sorry, Angela, staying with you.
Okay.
We will get to enforcement and transmission
Not
of
off the
awards.
hook yet.
If you look at the Queen Mary study, costs are important, and that's one of the biggest advantages of SIAC. So an important message to communicate. So if you could speak on that.
Yes, absolutely. It is not really a secret. In general, because we are able to gauge the entire maximum estimated total sum in total cost of arbitration at the beginning. So typically we would split our deposit collections into 3 tranches, but we exercise discretion in a sense where as to when we do call for them. We have a sort of a set timeline internally, but we do adjust according to the case and the timeline it's under. So if it's under an expedited procedure or even an early dismissal procedure, we tend to then truncate the call of deposits depending on which stage the arbitration is at. So we do take into account the potential that, especially during these times where companies are actually having financial difficulties and cash flow problems, we understand that, and we will take those into account when we decide when to call for deposits or whether to allow parties additional time to make payment. So I think our users who are familiar with the way we work, they would know that we are generally quite flexible as long as you explain to us by email about your position and help us to understand exactly where you're at, and perhaps give us an idea how long that delay would be, so we can also make adjustment on our end. So, I mean, the whole idea is that we want to ensure there's enough finances on hand ultimately to pay the tribunals. So we want to make things easier for parties, but we need sufficient reasons on our hand to be able to make the necessary adjustments. So I would say we have quite a bit of discretion, but obviously it will depend on the stage of the case. So if need be, and if depending on the stage of arbitration, registrar will still exercise discretion to consider a case suspended or withdrawn under Rule 34.6. So these are things we will take into account, but we will also exercise this discretion if necessary.
Yeah, I think that makes the position really clear. I would just add on by saying one thing that's interesting, and me and you have worked on quite a few of these together, is the sort of the wide variety of cases that we get at SIAC, because you might have a $50,000 case and a $5 billion case. And what is the deposit collection procedure going to be for each of those? And you really want to customize the process to a certain degree. So you have these internal milestones. We want to be commercial, but at the same time, it's a broad range of disputes. Let's we'll pause there on deposits. Perhaps there will be some more questions, but what I really want to ask you about is really the process for transmission of awards and some of the other services that SIAC is offering. So depending on where an award may be enforced, it could be multiple jurisdictions. What do parties do if they need an additional copy? How does it work? Is there electronic transmission, hard copy delivery? How are awards being transmitted at SIAC right now?
In general, we will send an electronic copy to the parties, and the hard copy will also follow. So within the next few days. But obviously, under these COVID times right now, the physical copy will be a bit tricky, given courier services are having their own difficulties as well. But we are doing what we can with the tribunal. We're all working together to make sure that the hard copies go out as soon as they can and reach the parties. As for additional copies, SIAC does not provide any additional original signed copies from a tribunal. Whatever you get at the end of at the end of the arbitration would be it. But parties can obtain authenticated or certified copies of these awards through us. And that's for awards stated in Singapore. So this is pursuant to the statutory power that's given to the Registrar of SIAC. So we can provide authenticated or certificated copy depending on what the parties need for the enforcement of the award in a particular jurisdiction. So what you can do is to go to our website again. There is a form online that you can fill up. You can complete it and then email that form to us with the necessary payment. The charges are all available online as well. So someone will get in touch with you once we receive the complete form and the payment.
That is a very big advantage under Singapore law, the fact that the registrar and deputy registrar do have the statutory power to authenticate and certify awards. Can you give us an idea of what this distinction is between authentication and certification? How does that work? What has your experience been with that? This is a long-running discussion at the institution that we have both been a part of.
Yes, Kevin, indeed. It was a long-running discussion purely because the IAA or the AA really doesn't really define what authentication or certification means. The same goes to the model law and New York Convention. It's just stated as if we're all supposed to understand what it is. But I suppose, you know, we work with it. But as far as SIAC is concerned, for our authentication or certification services, the difference between the two is this. So authentication, it's where we will provide a cover sheet on top of the copy of the award. It will certify that the award is an authentic award published in Singapore, and it also contains details of the delivery of the award to the parties. So that's what the cover sheet will say, and it will be signed by the registrar or the deputy registrar, depending on who's available at the time. So that's authentication. For certification, we will also similarly have a cover sheet, but it would purely just say, it will just certify that the document attached is a certified true copy. But the difference is the registrar will sign on each and every page, including of the award. So it really depends on what the enforcement jurisdiction needs. I understand that if you are enforcing in Singapore, you can do either, but maybe certain specific jurisdiction may only accept something along the line of certification where every page is signed. So the lawyers will have to find out where you are going to enforce and then let us know which service you would like to have.
What about, so obviously the arbitration agreement, the award is given effect in the legislation. What if you're a party for whatever reason, jurisdiction specific, that you need a certified copy of the commencement letter, of the contract, some of the other documents that have been filed in the arbitration? Is that something that SIAC can also do?
We have actually received queries like that before, and my colleagues, please correct me if I'm wrong. I vaguely remember what we did was we did provide a certified true copy only because we are the institution providing that original letter, so we are fully capable of providing a certified true copy. Yeah, it's rare, but we have done that before. Yeah.
You know, I can recall many moons ago when I was SIAC counsel, I actually had to give a certification that I was a duly authorized officer of SIAC. It was actually in this jurisdiction. It was the first international award that was actually enforced in that jurisdiction. The relevant law firm wrote an interesting article on it, and we had to be certifying and authenticating all sorts of documents. But thank you, Angela. I think that makes the award transmission process quite clear. So we're at about 10 minutes away from the end of this session. We are getting a lot of questions. With the indulgence of Angela, Dean, Dexter, and Thea, I am going to be just putting these to you because these are the questions that are very relevant, because this is what users need to know. So they're not really going to follow a pattern, and I'm just going to put it to you. Dexter, I am going to start with you. The question is that how involved are SIAC counsels in arbitrations that they're managing? How closely do they work with the arbitrators and parties on case management, or is this mostly left to the parties?
I think I would draw a line at the constitution of the tribunal, that stage. So pre-constitution, we work a lot with the parties when it comes to the commencement of the case and a lot of the pre-constitution applications, such as the expedited procedure, consolidation, joinder. But after the constitution of the tribunal takes over the reins of the arbitrations and issues directions to the parties through the procedural orders. And I think we only really get involved with the financial aspects of the case, collecting deposits to make sure that there are enough deposits for the tribunal and for SIAC at the end of the arbitration. And when the hearing is over and the award comes to us for scrutiny, I think that's where we work more closely with the tribunal in addressing certain aspects of the award and providing our suggestions. So I think, I mean, in a very brief sense, that's our level of involvement with the different people involved in the arbitration.
Yeah. Well, I mean, ultimately, I guess we are a service provider. We're there to assist the tribunal, assist the parties. One very common thing, well, maybe less common now, in terms of assisting the parties, what happens if one party writes to you separately on a case and says, hey, can we file an application under this? What is the generally accepted institutional process for you to do there?
The general accepted process is for all parties to be copied. So we wouldn't really respond to ex parte communications. We would ask them to resend with everyone in copy. Yeah.
Okay, thank you. Thea, I'm going to put the next question to you, the question that we touched on a bit during this session. What if a party or respondent is being uncooperative during the COVID period in response to a directed timeline under the procedural timetable set by the tribunal during pre-COVID? How does that work in terms of a procedural timeline before COVID and compliance with those timelines thereafter? I mean, this is a question more for the tribunal, but to the extent that you can offer some clarification.
I think it depends on a case-to-case basis. So for some of my cases, I have just constituted one under expedited procedure during COVID. So it depends on the industries involved and timeline. If ever you can do documents if you can do documents only arbitration, then it's also possible. But for a tribunal standpoint, I guess it would be better if the parties could just apply, then they could discuss within their own particular case. So adjustments can be made in the procedural timetable. But in my case, it is really varied. Some of my EP cases have been extended, but there are also new expedited procedure cases that have just commenced. So there's really no direct timeline during pre or during COVID.
Yeah. Would you say one thing that I've found somewhat heartening is that it seems that parties and tribunals are actually being quite cooperative, and that they're looking for a solution to try to take cases forward, agreeing on e-hearings, whether it's documents only. So I think that that has been a positive takeaway from COVID. Jean, I'm going to move over to you. Would you say in your cases, and certainly Thea, Dexter, Angela, chime in with your thoughts as well, do you see more cases being settled during COVID-19? Jean, if I could start with you.
To the contrary, actually, we actually see more parties requesting for an extension of time to pay their deposits rather than a settlement of cases per se. As in, we have always seen a couple, all of us who have seen like a settlement, we have reached a settlement streak at some point in time, but I don't think COVID has actually increased the number of cases being settled at this point in time. Further, I think parties are trying to avail themselves of provisions in our rules, like for example, time extension to file certain documents or time extension to make certain deposits instead of settling the case per se.
I'm going to chime in there if you don't mind. From my cases, the experience is similar, where parties ask for extension of time to make payments and whatnot. But what I observed is a lot of them, after asking for extension of time to make payment, ended up settling. So I think mostly a lot of times parties don't want to be out of pocket while they are discussing potential settlements or even in negotiation stages. So that is something that I do observe happening in my cases. Certainly, it helps for parties to get some kind of extension of time, either to discuss settlement or even just to find the fund to continue the arbitration. But I think so it's a bit hard to tell whether the settlement is caused by COVID at this point, because it just started. Parties are now asking for time to pay for now, but we'll have to wait and see whether it ultimately ends up settling. So maybe ask us in 2 months' time.
Angela, let me just stay with you on one of the questions. And one of the exciting things, of course, the questions are pouring in, and what's really nice to see is that there's just sort of SIAC friends and users from all sorts of jurisdictions, a lot of familiar names. And one particularly relevant question, and which we've seen recently, anecdotally, there are suggestions that cash flow limitations have sent parties more to third-party funders for funding. Of course, the funding regime in Singapore has been liberalized. Have you seen an uptake in funding agreements, and how has SIAC's practice note assisted in that regard?
Yes, we have a practice note directly relevant to third-party funding. It's mainly focused on the tribunal's duty to disclose if there is any third-party funders on board. Interestingly, a case that I recently, I have been ministry, a third-party funder came in halfway through the proceedings just recently. So, and also anecdotally, I've been hearing about business going pretty well for third-party funders, especially during these times when I think companies don't have enough cash flows to go around, and really they don't want to be paying the cost of arbitration at this point when they could channel it to their actual profit-making process. So this is where a third-party funder probably would come in pretty handy. And I think this might be a trend that might pick up. Yeah. But I think as far as we're concerned, we will require parties, and I think Singapore soft laws as well do provide for parties to disclose when the third-party funder is on board. And we would need to know that as well in terms of collection of deposits. So that is something we do look out for, and we do make sure that everything is in order.
Just briefly, the presence of a funder, does that impact on SIAC's timelines for the collection of deposits, or does everything proceed as per the normal course?
Normal, sometimes very swiftly, because third-party funders pay very quickly.
Okay.
It helps move things along. Yes.
Dexter, we've got a question, and going back to our discussion on the appointment of arbitrators. The question is, what's the approximate time frame within which an arbitrator will be appointed after the response to the notice of arbitration has been filed? Obviously, there's a lot of permutations and combinations to this. Let's assume sole arbitrator, single claimant, single respondent, everyone pays their deposits on time. How long does that normally take, and what's the process there?
Right, so I think it's a little bit difficult to put a specific number of months on it. I'm not sure if you also mentioned other sorts of pre-constitution applications, such as consolidation. If we have those applications, then obviously it will take a bit longer, but assuming that there is none of that, I would say that it also depends on whether the arbitrators that are approached are conflicted. And sometimes they take a little bit longer to get back to us, especially during this COVID period, if their offices are closed. So this is something that we would always be in communication with the parties, and if the parties need an update, they can always request us, and we will respond on a case-by-case basis.
Yeah, and I guess the key component there, which institutional representatives around the world would be very aware of, is that the timeline in the clock really starts ticking from the payment of deposits, because we cannot constitute a tribunal without having certain deposits on hand. As we've discussed, we try to do this in the most commercially sensible way possible. But if you want your arbitrator to be appointed quickly, the best thing to do is make sure that your share of the deposit, as claimant or respondent as the case may be appointed or is done promptly. An interesting provision in the SIAC rules is Rule 10.2, whereby the sole arbitrator is appointed 21 days from the commencement of arbitration, or relevantly, if any party so requests. This can be important during the time of COVID. So if you have a situation where the claimant and the respondent have no chance of agreeing on a sole arbitrator, a party can just say in their notice even, there is no chance of the parties agreeing. We've been in discussions. We would ask that SIAC appoint the sole arbitrator forthwith. So then you can get, this really functions as the expedited formation of the tribunal, and it may also impact on whether you might need urgent interim relief. So you have this option of the emergency arbitrator, and then you could also look for a very quick constitution of the tribunal. But as Dexter rightly pointed out, there's a lot of permutations and combinations. From an SIAC standpoint, we act very quickly on these, and we do tend to get these tribunals up and running very quickly. Let's just take a few more questions. We're a bit over time, but we are getting a lot of very good questions. Jean, let me put this to you. The question is, with the rise of documents-only arbitration, would the role of parties' counsel be diminished in the future? I guess this is a question as to the future of arbitration advocacy. Any thoughts on that, Jean?
I guess not. Wow.
I mean, I guess I'll start. That is an interesting question. I mean, one thing that you have to look at is, I guess, documents only generally. And so you have to look at, under the model law, if a party requests for a hearing. So if they haven't agreed to a documents-only procedure, how should a tribunal handle that? I think there's lots of efficiencies that can be gained by documents-only procedures, but there's certain cases, whether it's virtual or in person, where that arbitration advocacy is still going to matter. Jean, I think one thing that's interesting when I'm looking at notices, and I'm sure with you, especially in these sort of big value cases, those cases are very close, because if it wasn't a 50-50 case, then the parties with their skilled lawyers probably would have been able to settle it out. So oftentimes the facts and the law are very close, and that's where the arbitration advocacy sort of falls in. So from my standpoint, I still think that the role of the advocate will continue to be important. Maybe we'll just run down, and anyone, Thea, Dexter, Angela, Jean, if you have any thoughts. As SIAC counsel, again, you guys are handling hundreds of cases. Is any last advice you can give to parties on how to navigate their way through the sort of institutional process during the time of COVID-19?
I'll go first. Oh,
go ahead. Please.
You volunteered. Very quickly. Probably what we all already know internally, but I thought it'd be good to just spell it out. I think the entire secretariat is run on the same motto, rather, being that we're always here to help. We tend to be very, I would say, agile and flexible in the way we approach our processes. I mean, we have our rules. We will make sure that we're in compliance with it, and we will nudge the parties of tribunal about complying with them. But we are also, I think, what I would like to remind our users is that, especially during these times, we're actually aware of difficulties that parties may have or tribunal may have on their cases, various stages, definitely. But what I wanted to point out or emphasize on is that the case counsel are all here to help. And so treat us as your friend and let us know a specific difficulty that you have in your case. And we will really do what we can to try to accommodate or make things go as smoothly and as quickly as we could. So yeah, so please feel free to approach us or email us. We'll get back to you, and we will do what we can to accommodate. That's my main point, really.
All very sage.
Right.
Anyone else?
I think in the current COVID times, time and cost savings are especially important to parties. So parties should actually look out for more of our provision under our rules that can actually aid parties in expediting the entire arbitration process, like for example our EP, EA, or ED procedures, or even say Rule 27G, where you can actually apply for an award for unpaid deposits in a situation where, say, the respondent is not responding and the claimant actually has to pay on behalf of the respondent. So there are many avenues in our rules that a party can actually avail themselves of.
Yeah, good point. Thea, thoughts?
So I think just to summarize what my esteemed colleagues said, it's really more of SIAC being user-friendly. Like in the morning, I get so many, back when we were still at the office, I get so many calls about the procedure, and counsel is always able to answer. Then second, regarding COVID-related questions, you can still contact us via the phone number you can find on the SIAC website. Then you can also email casemanagement@siac.org.sg. So we will try to respond as fast, as efficient as possible for these cases. Then I guess SIAC rules already have the tools, for example, as my colleagues mentioned, the EPEA, that can cater to their specific needs during this time. So I think that's very interesting, especially if your case pertains to a lot of different jurisdictions or governing laws. Back to you.
Thank you. Dexter, closing thoughts from you?
Well, I think because of the COVID, everything is starting to slow down a little bit, but things seem to be ramping up over here. So I think that there needs to be a little bit more understanding on everyone's part during this period to deal with the crisis, and I think that's most important when trying to resolve the disputes in arbitration. Yep. I don't really have much more to add. Yeah.
Absolutely right, and just building off all of those comments. I mean, SIAC is fully operational. We're as busy or busier than we've ever been. Of course, we had an all-time record in 2019, and things are looking very good. And really for 2020, and really the fundamentals of arbitration start to govern here. Arbitration is flexible, it's fast, it's cost effective. We in arbitration have been looking at ways of running things virtually for a lot of years. So arbitration is very well placed to be able to resolve disputes during the pendency of the COVID-19 pandemic. One thing I guess that we would ask of all our users is please check in on the SIAC website for the case management updates. You can look at our FAQs, all of the newsworthy events. So please do stay dialed into the website. And as mentioned, this is a part of a series of webinars that SIAC is going to be delivering to its users. Our next webinar is scheduled for Tuesday, so please do check the SIAC website. And on behalf of this all-star lineup of counsel, on behalf of myself and SIAC, we thank everyone for joining us today. If you have any additional questions, please feel free to send them by email. Thank you very much.
Thank you. Thank you, Kevin.
Thank you.
Thank you, Kevin.
Thank you, Kevin.